Hello YouTubers, and a special warm welcome to my fellow Queenslanders. Following on from my previous video podcast exposing Lexon Insurance and my decision to include developer Jim as a defendant into our damages claim, as I thought Jim needed to explain why there were so many legal issues. Why there were so many problems with the estate. Why wasn't our access easement registered? Eventually, the big day arrived. It was the 7th of October 2010. It would be the first hearing to include Jim and to seek leave to do so. Typically, when you arrive at court, you wait in the halls of justice, and then you attend call over. This takes place every morning at around 10 a.m, and all the listed matters for that day are divided up amongst several justices. You wait your turn when everyone is on the clock, so most lawyers don't care. They get paid irrespectively, no matter what happens. I looked around, hoping to see if our nemesis was there, as I thought scoundrel Jim would show. Sure enough, he didn't. Typically, during this wait period, opposing lawyers will swap their submissions, which, just to explain, they are also provided to the court justice. They identify what the lawyer's arguments will be during those days' proceedings. It was decided that our matter would be heard by Justice Philip McMurdo. Our lawyers and I entered the courtroom, and I remember the elevated observation gallery, which seemed to be quite distant from the bar within the courtroom. I found a seat and then waited and listened as proceedings began, when suddenly Justice McMurdo sought my attention, declaring he had an association with a new lawyer, Jim. Justice McMurdo bellowed out and asked me if I had any issues with his declaration. It took me by complete surprise. Ultimately, I had to approve, or I did approve, but what choice did I have? After years of litigation, you can imagine the costs involved. If I refused, my family and I would still be burdened with the costs associated with attending court that day. I trusted everyone. McMurdo was a Supreme Court Justice. Soon afterward, Justice Philip McMurdo allowed the proceedings to be heard. The developer Jim was to be included as a defendant, or I tried to get him included as a defendant, and the hearing was set down for the 22nd of October 2010. Several days later, I received a phone call from our lawyer stating that we could inspect the records at lawyer Jim's office. We were then informed that Jim had a copy of the unregistered easement document. I thought that was great news until I learned that it could not be registered because of indefeasible title. And that advice was provided or based on the learned $30,000 opinion penned by the QC and the subordinate barrister that I paid for. Essentially, it meant that the Department of Natural Resources had issued titles, and those titles were set in concrete. The error could not be remedied. The group title plan had already been registered, but to me things didn't add up. Why would the developer of the estate have in his possession the unregistered easement documents that he, as a developer, and he also happened to be a lawyer? My lawyer and I arrived at Jim's office, and of course Jim wasn't there. We were led to a little room and were given a few documents to inspect, including the unregistered easement document. In hindsight, if it was all a big mistake or a big misunderstanding, one would think that developer Jim would have explained what went wrong. Initially, I confess, I thought the error might have occurred because the previous owner of our land, Mr. Raymond Burnt, had lost mental capacity. He was sick. Looking back, you would think developer Jim would want to explain what had happened. Instead, he was nowhere to be found. Why stay around and hang yourself? It was my turn, again, at playing the strategic game of chess. However, no one advised me we were playing this game. The application was heard by Justice McMurdo on the 22nd of October 2010. I remember that day well, as there were 4 separate law firms involved, although only 3 firms appeared. It was the body corporate's lawyer and Jim's lawyers and our lawyers, including our expert barrister. Lexon insurance lawyers represented the former lawyers against the claim of negligence. Jim, however, didn't show. He put his faith in his associates. Arguments were heard over a 4-hour period, and then ultimately Justice Philip McMurdo found against us, stating we were not protected by the Integrated Planning Act of 1997 and we had no direct relationship with developer Jim. In hindsight, and peering back in time, and knowing Justice Peter Lyons had managed both sets of proceedings behind the scenes, including the claim against our original negligent law firm via Lexon Insurance, and combine that with our claim against the body corporate for negligence, they were obligated by law to know what their responsibilities were towards us as neighbours. The body corporate chairman always knew we were entitled to an easement. As the FOI file revealed, he was in legal proceedings over the same easement in 1995 against another developer. A dispute is great for business if you're a lawyer. Supreme Court Justice Peter Lyons, as a property expert, must have coached or discussed the matter with Justice Philip McMurdo, as any independent study of the law proves we were always protected retrospectively by the Integrated Planning Act of 1997 under Section 6.1.24, and that the estate was not subject to indefeasible title, as the council development approval was dated the 9th of July 1987, and the Integrated Planning Act applied retrospectively to an earlier date, which was the 13th of June 1987. Supreme Court justices are not appointed to their position by being ignorant or thoughtless. They're highly intelligent people. However, that is why I am sharing the story with you, as I want you to decide. I need to read to you the independent property report by property expert Mr. William Purcell, as it is the reason why Justice Peter Lyons QC provided the original correct initial judgment on the 4th of April 2012, and by fluke he was forced into that position because I refused to give in. The correct judgment was never sealed or placed into the court file. Mr. Bill Purcell's property report states at his section 4.72, when Chapter 6 of the Integrated Planning Act of 1997 commenced on the 30th of March 1998, Section 6.1.241 would have operated, I would think, so as to attach the conditions of the development approval to the 11 lots and common property created by Group Title Plan 1836, and so as to bind the successors entitled to those lots. That provision is contained in Chapter 6, Division 6. Those provisions are not all that easy to construe. But on my analysis, the development approval was a continuing approval, and for the purposes of Section 6.1.241, Bill continues. At 4.73 in his document, by virtue of Section 6.1.232 of the Integrated Planning Act, a continuing approval and any conditions attaching to it took effect as if they were a development approval. It was in the form of a preliminary approval or a development permit for the purposes of the Integrated Planning Act. Please, let me explain what is meant by the concept of a continuing approval. Should you you and Mr. and Mrs. Jones decide you would like to build a tennis court in your backyard, your local city council will agree or might agree with the proposal, and if so, grant a development approval, but with conditions. Typically, they will allow you to install lighting. However, that lighting must be turned off at 10 o'clock in the evening. This means that condition is tied to the land. Should you decide to sell the property, the next homeowner is obligated to turn off the lighting at 10 p.m. Now let's get back to Bill Williams' property report. At his section 4.74, the relevance of that to a body corporate and lot owners who were bound by continuing approval under IPA of 1997 was the development offence provision as well. In section 4.33.1, it stated that a person must not contravene a development approval, including any condition of approval. The maximum penalty for an offence under that section was 1,665 points, a large penalty. Bill writes at section 4.75 of his report, for that reason, it was incumbent upon the committee members of bodies corporate and professional body corporate managers to manage the risk of such contravention. That requires, amongst other things, identifying the conditions of the development approval, which applies to them. At section 4.76, he writes, consequently, one would have to expect a body corporate committee which is comprised of lawyers, accountants, and the like, as was the case with that subdivision, Group Title Plan 1836, to have become so informed. At 4.77 he writes, if those observations are valid, or if the body corporate did become so informed, the records kept by the body corporate, or at least those relating to Lot 1's access over Lot 2, which is our land, and their land was Lot 2, including the burnt letter, should have contained that information, and those records should have been disclosed by the body corporate in the litigation between the body corporate and the worker's family. Now let's get back to the story. On the 19th of April 2011, I received a letter of demand via our lawyer seeking payment of $17,479.69 as we lost the court case from the law firm acting on behalf of developer Jim. Jim was demanding money. I borrowed those funds from my brother, as it is essential you never give in and you must find the money, and I settled the account. Then, can you believe, on September 27, 2011, I received a refund cheque for $17.45 from Lexon Insurance. They wrote to our lawyers advising, we refer to His Honour Justice McMurdo's decision on 22 October 2010 to dismiss your clients, workers, our application to join our clients to those proceedings. As you know, in conjunction with dismissing your client's application to join our client, that was Jim, His Honour also ordered that your client, that's me, pay our client's costs of the failed application. Our client's costs of and incidentals to defending your client's failed application, including the cost of briefing counsel to appear at the hearing on 7 October 2010. Honest enough to return $17, I thought. During the proceedings before Justice Philip McMurdo, on the 22nd of October 2010, there were three separate parties before His Honour. Our lawyers and the senior barrister who's paid for by Lexon Insurance, representing our former negligent lawyer, plus the lawyers employed by Jim, the developer, who employed counsel to represent himself. Every lawyer, including the justice, had a lifetime association with Lexon Insurance. I was the net beneficiary of the law, but cronyism ensured a loss. I must repeat, Justice Peter Lyons, as a Queen's Counsel specialising in planning and property law, managed both sets of proceedings behind the scenes, which means he must have communicated or discussed our matter with Justice Philip McMurdo. Our twin proceedings were, or the two proceedings under management, was us against our previous negligent lawyers and us against the body corporate of the Community Title Scheme, GTP 1836. Justice Peter Lyons, QC, obviously had an acute understanding of property law, as the Brisbane City Town Plan remained consistent with minor amendments from 1964 through to the 30th of June 1987. The document consisted of approximately only 140 pages over 22 years. In 1978, the Minister for Everything in Queensland, the Honourable Russell Hinds MP, included the iconic principle of a transitional section, the Section 22B, which clarified how the town plan would be treated when it would eventually be superseded. The suggestion that these property experts had no idea the transitional section 22B of the 1978 town plan was instrumental to our proceedings is beyond ridiculous. It is also obvious Peter Lyons QC had communications with the Queen's Counsel and his subordinate who penned the misleading $30,000 opinion, as they were all property experts, and there's only a handful of them in Brisbane. Justice Philip McMurdo found in Lexon Insurance and developer Jim's favour, even though Lyons provided the correct judgment originally and always knew Workus was protected by IPA of 1997. I did my best work under pressure during my deepened sleep. My subconscious worked tirelessly, and I remember waking at 4 one morning, perhaps in 2013. I didn't want to wake my wife. I quietly slipped away from bed to study my files. Eureka! I struck gold. I could not believe my eyes. It was amazing. I looked through developer Jim's file and discovered the refund check for $17.45. Who photocopies a refund check? It was a refund check from Lexon Insurance. What insurance company anywhere on planet Earth would honour a professional indemnity insurance claim against a negligent lawyer acting as a director of his own development company who neglected to register an easement, which is a necessary development condition imposed by the Brisbane City Council and subject to huge penalty under the Integrated Planning Act of 1997, as advised by Mr. William Purcell's independent property report, unless they already knew the outcome. Obviously, it was all predetermined. Any other conclusion does not make sense. All three law firms in those proceedings had a relationship with Lexon. By filing that claim with Lexon Insurance 22 years after the event, it means that developer Jim admitted he was acting as a lawyer the whole time. He was acting as a lawyer when he swindled everybody involved. It's corruption of the highest magnitude. Lexon Insurance happily obliged, all the judges happily obliged, Premier Palaszczuk happily obliged. They're all corrupt. They're as corrupt as they get. Two of them were financed by Lexon. My own senior lawyer was no fool. He must have known. We didn't stand a chance. It was all rigged. Dirty, rotten scoundrels. Justice Philip McMurdo was also the lead justice in the Court of Appeal. Go figure. These men are all the same age and had been practicing law since university. They're mates. Now, no wonder our queen of cover-up and her cronies kept this story from being made public. My evidence did not meet the terms of reference into the inquiry into corruption within the public service. Rules for them and rules for the rest of us. Nobody's above the law. Yeah, right. It is no wonder no journalist in Australia would help me. They don't dare challenge authority. I mean, look at what happened to Julian Assange. He too is a fellow Queenslander. How can any self-respecting English politician or government hand over an Australian citizen to the American government that has no jurisdiction over him anywhere in the world except the United States. The American government has no jurisdiction in Australia, England or Europe. The crimes he helped expose is on par with many other media organisations that fact-check his evidence. I swear I love North America, I love its people, and my experience travelling throughout the United States up to 3 times a year throughout the 90s. I can tell you, I never saw any racism. The people were lovely. It is the media beating up hatred. I am begging you to learn how to think and not what to think. Let's take the poisonous, indoctrinating smartphone away from our children and give them their lives back. You can't trust the crap that is published. Nothing is real. And if you need to be a helicopter parent, let's just contact Nokia and reinvent the old digital phone. Personally, I think the original digital phone should be the only option for anyone under 18 years of age. Save them from the bulldust, the rubbish. The evidence submitted here proves the judicial systems around the world are literally swimming in cronyism. You only get one chance at life, so make the most of it. And I say, free Julian Assange and rid ourselves of these power-hungry government officials, lawyers. They lack all moral authority to judge anyone. The entire judiciary is broken throughout the Commonwealth and the Anglosphere. You're guaranteed a fair trial and due process unless you can prove you didn't get one. They're bastards. This video is designed to give you a quick overview of the obvious sleight of hand used by the deep state, the tactics they use, the deliberate paraphrasing of the law when required. Please help me start a Me3 movement on Twitter if you have been deliberately wronged by the judiciary anywhere in the world, and that you visit www.whentheftislegal.org to force the Queensland government into establishing a royal commission into corruption within the judiciary that is not predetermined via change.org. I am also calling for the immediate resignation of the Queen of Cover-Up, our Premier, Anastasia Palaszczuk, and her cronies, including her public relations cabal. Please remember to like every podcast so we improve its distribution around the world, or refer your friends to subscribe to my channel. It is very important. Help me correct the current madness we are all experiencing, as we need to expose another fallacy, the fallacy of the separation of powers. And if inclined, please leave a donation to help fund this venture, as I need your help. And to all the boys out there that want to be men, here is some advice. Pain is temporary, but glory is forever. Everything else is just fucking noise. See you again soon, and always remember, she'll be right, mate. Never fear, Randolph is here. Aloha to our friends in Hawaii.